What does rendered service to the nation mean? In Malaysia, this phrase seems to have a different, even opposite meaning. Here's a problem. The Prime Minister recently said that he had addressed the board while serving as the Federal Territories Minister, and recently, the current king, about the former Premier Najib's services unto the nation. That got me thinking. What does service to the nation mean? When one becomes a politician, one enjoys a huge salary, is granted free vehicles, personal guards, and police escorts. The nation lavishes him with the 3 Ps: princely titles, posts, and pensions. Then the politician is convicted for corruption. Contrast that with a convict who had purloined some milk or some mangoes. Is it right to conclude that the politician has rendered unto the nation, while the latter is to be treated as a social leper, deserving little mercy? Is that not an odd interpretation of the phrase rendered service to the nation? Consider what that phrase should really mean. Is it not true that the phrase, sorry to tie you with this, rendered service to the nation, must have the same meaning as those in the following context? Please do not get offended. This list is in no particular order. Number 1, school teachers and university lecturers who spend exhausting hours venting their spleen, nurturing our children to become good citizens, accompanied by academic or professional skills. Number 2, medical professionals who risk their very lives saving the ill. Number 3, judges who go about their business quietly, upholding the law and order without being able to speak publicly of their problems and their challenges. Number 4, public prosecutors who honestly and efficiently prosecute criminals, honest police officers who succumb to their injuries while stopping a crime. Number 6, soldiers killed in defense of our nation. Number 7, firefighters who brave the flames and lose their lives just to save victims. Number 8, civil servants who spend their time quietly helping the poor and the needy. Number 9, members of NGOs who brave the uncaring society and assist the poor, the oppressed, and the unrepresented. Number 10, members of the local municipal council who clean out the sewages so that you would not be inundated with your own disposal. How come all these people are not recognized to have served the nation? Why is it in Malaysia a politician assumes a higher standard, a higher status, requiring royal titles and a huge lifelong pension, that too after serving only 4 to 5 years? Why do politicians require recognition and pardons for clear transgressions of the law? Contrast those questions with this real-life example of how a court reacted when the phrase service to the nation was used. This was in the Tan Koon Swan case in Singapore. He was the MCA president in 1986. He was charged in Singapore for his role in a scandal. Now, why did he get charged? Tan was implicated in a stock fraud in a Singaporean company called Pan Electric Industries. Now, you must remember that mitigating factors during sentencing are different from factors that a pardons board would consider except in 2 situations. We come back to Tan Koon Swan. He pleaded guilty. That became, in law, a mitigating factor. However, mitigating factors that the court considers during sentencing, as I said, differ from those considerations of a pardons board. In Tan Koon Swan's case, services to the nation played a crucial role. So, Tan Koon Swan's counsel argued that Tan should not go to prison because of Tan's services to his nation and to his party. This argument did not factor in the consequences of what Tan had done to society. One critical principle the court considers before passing sentence is the interest of society at large. This principle played a huge role in Koon Swan's case. If you recall, the pan-electric disaster ruined 5,500 shareholders. Their debts totaled then Singapore 480 million. In 1985, that was equivalent to 1.2 billion ringgit. What did the Singapore judge say about this so-called service to the nation argument? Mr. Justice Lai Kiew Chai was unmoved by pleas of national service. He said Tan's offence had struck at the very heart, integrity, reputation, and confidence of Singapore as a commercial city and financial centre. He sentenced Koon Swan to 2 years imprisonment and a fine of 232,000. There are two key takeaways from the Tan Koon Swan decision. Firstly, the integrity point. The judge referred to the principle of integrity, reputation, and confidence. If you recall, a leader has served his nation when his leadership is conducted on the basis of an unflinching commitment to integrity. Who would claim the title in this country? However, when a corrupt leader betrays the trust of his nation and the confidence it has placed in him, he cannot be said to have served his country. He has done nothing but rendered a great disservice to it. Compare that with what Datuk Sri Najib argued in mitigation at the High Court and at the Court of Appeal. In trying to mitigate his sentence, Najib also spoke of his service to the nation. The defense referred to Najib's aristocratic background, his presidency of UMNO and Barisan Nasional, and the huge responsibilities he had held as a member of the cabinet and state leadership ever since he was 25. The Court of Appeal, in considering these arguments, cited several cases which were pertinent to the point. Recalling the words of Mr. Justice Raja Azlan Shah, as His Royal Highness then was, in a case called Dato Haji Arun Idris, His Lordship referred to the betrayal of the oath of office. He said, referring to the accused, "You allowed avarice to corrupt you. In so doing, you have not only betrayed your party, your cause, but also the oath of office which you have taken." Pointing to this passage, the Malaysian Court of Appeal recalled how His Majesty Raja Azlan Shah had referred to the frightening decay in the integrity of some of our leaders. The Court of Appeal spoke of the need to protect the nation. The court said the courts in upholding the rule of law would have to do what's necessary to ensure that this modern day plague, corruption, is eradicated for the good of the nation. The Court of Appeal therefore rejected Najib's explanation of national interest. It said this is definitely not something that can be said to have been done in the national interest. There is no national interest here, just national embarrassment. So that put an end to Najib's arguments on the service to the nation point. For its part, on the 31st of March 2023, in dismissing the appeal, the Federal Court said that it upheld the decisions of the other two courts. Now to the second point. Would it not be odd if the Pardons Board tried to revive the very same argument, service to the nation, during the pardon process, and if it could accept that the corrupt leader had in fact served his nation? The tragic cases of Tan Koon Swan and Dato Sri Najib Razak highlight that neither a court nor the Pardons Board should be swayed by arguments of service to the nation. Is it not time for the Pardons Board to establish a clear guideline? Should it not have a guiding principle to the effect that if a politician is convicted of corruption, the prima facie assumption is that he did not serve his nation, he did not serve his country, he did not serve his king, he did not serve his people, and he did not serve his party. That is all I have to say. Thank you and goodbye.